Welcome to the deep dive.
Good to be here.
Today, we're really getting into the weeds on a core part of patent prosecution. What happens when your claims get rejected by the USPTO? Think of it as navigating a really common challenge.
Absolutely. Especially if you're studying for the patent bar, MPP Section 706, which is our focus, is fundamental. It covers the why and the how of claim rejections.
So we're digging into Chapter 700, specifically Section 706, on rejecting claims. We'll look at how examiners do it, the different kinds of issues they raise, and importantly, what you do next.
Exactly. We'll pull in related bits from other MPP sections mentioned in the source material too, things like appeals, specific rejection types, the whole picture based on what the MPP says.
Right. The goal is to make this MPP section, Section 706, feel a bit less daunting and highlight what you really need to grasp. Okay, let's dive in.
So it all starts after the examiner has, read your application, figured out the invention, and done their prior art search.
Standard procedure.
Right. Then they take each claim and see if it actually meets the statutory requirements. You know the ones.
The big hurdles, 35 USC, Section 101 for utility and subject matter, 102 for novelty, 103 for nonobviousness, and 1012 for, describing it properly and claiming clearly.
Precisely. And if any claim falls short on any of those, the examiner has to reject it. MPP 706 is very clear on that.
It's not optional for them.
No. And the rejection itself needs to be thorough. They can't just say rejected. They need to explain why, cite the specific law, and if it's based on prior art, like a 102 or 103 rejection, they have to point to the specific references and explain how those references teach or suggest your claimed invention.
Okay, so they build a case. They have to show, based on the evidence, why the claim isn't patentable. MPP 706 emphasizes that, right?
Yeah.
Establishing that prima facie case.
Exactly. They need to show it's more likely than not unpatentable based on the information they have.
Now, something MPP Collabs 706 really hammers home, and you see this in practice, is the difference between a rejection and an objection. These sound similar, but they're handled completely differently.
Oh, absolutely. Critical distinction. A rejection goes to the substance, the legal merits of the claim itself. Does it meet 101, 102, 103, 112?
Like we just discussed, novelty, obviousness, description.
Right. And because it's about the substantive right to a patent on that claim, a rejection is appealable. You can fight it by taking it up to the Patent Trial and Appeal Board, the PTA. That whole process is governed by MPP Chapter 1200.
Okay, substantive issue, appeal to PTJEB. Got it. So what's an objection?
An objection is about form, not substance. It's about procedural or technical correctness. The example given in the focus summary is perfect. Say you have Claim 3, depending on Claim 1.
Okay.
Claim 1 gets rejected, maybe it's obvious under a 103, but Claim 3 adds something genuinely new and non-obvious. So Claim 3 might be allowable on its own merits.
But it depends on a rejected claim.
Exactly. So the form is wrong. Claim 3 improperly depends on a Claim 1, that's currently rejected. The examiner wouldn't reject Claim 3 on substance necessarily. They would object to Claim 3 because of that improper dependency.
Ah, I see. So the claim itself might be okay, but the way it's written or connected is faulty.
Correct. And because it's a formal matter, not a substantive one about patentability, objections aren't appealed to the PDT. They're petitionable to the director of the USPTO. That's covered elsewhere. Like MPP chapters 1000 and 1100 on petitions, totally different track.
That fork in the road makes a huge difference in how you respond. Okay, let's unpack the main types of substantive rejections MPP 706 deals with, starting with the most common, prior art rejections under 102 and 103.
Right. Section 102 is about novelty or anticipation. Basically, if your exact invention is already described in a single prior art reference, a patent, a publication, whatever qualifies under the statute it's anticipated, boom, 102 rejection.
Straightforward enough if you find that smoking gun reference. What about 103?
Section 103, obviousness, is usually more complex. Here, maybe no single reference shows your whole invention, but the examiner argues that the differences between your claim and what's in the prior art would have been obvious to someone skilled in that field at the time you filed. Often involves combining two or more references.
And MPEP 706 guides examiners on how to properly make and articulate these 102 and 103 rejections.
Yes, setting out the legal basis and factual support needed. Now, an interesting twist mentioned in your sources, under the MP 800 series actually, is the idea of provisional rejections.
Provisional. Sounds temporary.
It kind of is. This happens when you have, say, two applications pending at the same time. Maybe they're from the same inventor or commonly owned. One application hasn't published or become a patent yet.
So it's not technically prior art yet.
Not yet, but the examiner knows that if or when it publishes or patents, it will become prior art against the claims in the other application under 102A or potentially for obviousness under 103.
So they reject it now in anticipation.
Exactly. They issue a provisional rejection. It's provisional because it depends on that other application actually becoming prior art later. Your source material mentions specific form paragraphs for this under both AIA and pre-AIA law, showing it's a standard procedure to flag these potential future issues based on related pending cases.
Huh. Okay, managing related applications gets tricky. So if you're facing a standard 103 obviousness rejection, what are some ways to argue against it? Your notes mentioned teaching away.
Right. Teaching away is a strong argument. You look at the references the examiner combined. If those references actually suggest not combining them or seem to steer someone skilled in the art away from making the modification the examiner proposes, you can argue the combination wasn't obvious. MPP 2145, referenced via Chapter 1200 in your materials, discusses this.
So you're saying the prior art itself points in the opposite direction of the invention.
Essentially, yes. It undermines the examiner's logic for combining things. But as your sources hint with the Dunry-Hedges case mention, you have to be careful sometimes. Other things in the art, even things you cited, can complicate that argument.
Always nuances. And related to that, common ownership or joint research agreements can sometimes prevent certain things from being prior art, right?
Yes, that's crucial too. Under certain conditions defined in the statutes and detailed in MPP sections like 2146 and 2133.03a, prior work done by the same research team or company might be disqualified as prior art for obviousness purposes. You have to meet specific requirements, but it can overcome rejections based on closely related internal work.
Okay. Beyond 102, 103, another big category is double patenting. What's the core idea there?
Double patenting, covered mainly in MP 800, is about preventing someone from getting multiple patents on the same invention or on obvious variations in a way that improperly extends their patent monopoly.
2 bites at the apple, basically.
Sort of. There are 2 main types. Same invention. Double patenting is statutory, based on 35 U.S.C. 101 saying you get a patent. It's rare because it means the claims are identical in scope. Much more common is non-statutory or obviousness type double patenting. This is a judge-made rule.
And that's where the claims aren't identical, but one is just an obvious variation of the other.
Exactly. And the usual way to fix this, if the rejection is proper, is by filing a terminal disclaimer.
Ah, yes. The terminal disclaimer under 37 CFR 1.321.
Right. You basically agree that the second patent will expire no later than the first patent, cutting off any potential term extension. That usually overcomes the non-statutory rejection.
Your notes also flagged provisional double patenting and design utility cases and a link to restriction requirements.
Yeah, special situations. If you have a design patent and a utility patent claiming basically the same inventive concept, a provisional double patenting rejection might arise while both are pending. And the restriction link is important if an examiner makes you choose between inventions, a restriction. 35 U.S.C. 121 usually protects you from the non-elected claims being used against the elected ones later.
Usually.
But if that restriction requirement is later withdrawn because it was found improper, as highlighted by the Henry Ziegler case mentioned in the context of MPP 100, you lose that Section 121 protection. Then suddenly, those previously non-elected claims could face double patenting issues against the elected ones.
Wow, okay. Restriction practice had deep implications. Let's shift to 35 U.S.C. Section 112 rejections. This seems broader, covering description, enablement, clarity.
Section 112 is definitely broad. It ensures the patent actually teaches the public how to make and use the invention, written description and enablement under 112A, and that the claims clearly define what the invention is, definiteness under 112B. MPP 706 covers rejections under all parts of 112.
And one specific issue your sources highlighted under 112B involves means plus function claims.
Right. That's under 112 now, or pre-AIA. It was the 6th paragraph of 112. You claim an element as a means for performing a function, like means for fastening.
Okay.
The rule is, if you use that language, your specification must describe the specific structure, material, or acts that perform that function. If you don't provide that corresponding structure, the claim term is considered indefinite under 112B. The In Red Donaldson case, cited in your sources via MPP 2100, is a key case on this.
So you can't just claim a function without explaining how it's done in the invention.
Exactly. The disclosure has to support the functional language.
Your notes also mentioned sequence listings in biotech and how they relate to 112.
Yeah, MPP 2400 and related rules like 37 CFR 1.821, 1.825 WIPO ST.26 have very specific requirements for disclosing nucleotide and amino acid sequences. If you don't follow the format or if the sequence isn't properly supported by the original disclosure, you can get a 112 rejection, often for lack of written description, 112A, or because adding it later is considered impermissible new matter.
And design patents have their own flavor of 112 issues, too, based on the drawings.
Absolutely. For designs, MPP 1500, the drawing basically is the claim. So if the drawings are unclear, inconsistent, or just poor quality, the claim fails 112A and B because it doesn't adequately disclose or define the design. Also, trying to describe variations in writing that aren't actually shown in the drawings, that's a 112 problem too.
Okay, so 112 is quite versatile in how it can be applied. So you get one of these rejections, 102, 103, 112, double patenting. What happens next, according to MP 706? You have to reply.
You do. 37 CFR 1.111 governs the reply. You generally have a set period, often 3 months extendable up to 6, to file a response to a non-final office action. And MPP section 711.02a details what makes a reply fully responsive.
And if it's not fully responsive?
That's bad news. The application can be held abandoned. The examiner typically sends a notice saying the reply was insufficient and gives you a chance to fix it, usually by filing a complete response plus a petition and fee, maybe needing an extension of time fee too. Form paragraph 7.91 is often used for this.
So dot your I's and cross your T's. Address everything. What about trying to add more arguments later, like a supplemental reply after you've already filed one?
MPP section 711.02a says supplemental replies generally aren't entered as a matter of right. An examiner might enter one if it, say, cancels claims or adopts their suggestions, but they don't have to. The best approach is always to make your first reply fully comprehensive.
Good advice. Now, when making arguments in that reply, your sources mentioned something interesting from MPP section 0005 about who can make them, citing in red to blau.
Yeah, that's a neat point. While usually a registered patent attorney or agent handles prosecution, the arguments themselves are considered on their merits, regardless of who makes them inventor, assignee, etc. The rules were clarified to remove language suggesting only arguments from registered practitioners count.
Interesting. And you can also submit evidence, like affidavits or declarations under 37 CFR 1.132.
Absolutely. Rule 132 declarations are a powerful tool mentioned throughout the MPP, including 711.02a and for designs in Chapter 1500. You can use them to submit evidence of things like unexpected results, commercial success, long-felt need, or expert testimony to show your invention wasn't obvious, for example.
Is that the same as trying to prove you invented something before a prior art reference date, like swearing behind?
No, that's different. While a 132 declaration provides evidence on patentability points like obviousness, proving an earlier date of invention to overcome a specific prior art reference under pre-AIA law, especially if it might lead to an interference, involves different procedures. Your sources point towards MPP 2300 and rules like 37 CFR 41.202 for interference context. Rule 132 is more for other types of factual evidence.
Got it. Okay, so you've filed your fully responsive reply, maybe with arguments and evidence. What does MP 706 say the examiner does then?
Well, under 37 CFR 1.112, the examiner must reconsider the application. They look at your amendments, your arguments, your evidence, and decide if you've overcome the rejections.
And if they're still not persuaded?
If the issues aren't resolved and the examiner thinks further back and forth on the substance isn't going to lead to allowance, they can issue a final rejection under 37 CFR 1.113. MPP 706 explains the basis for making an action final.
Final. Sounds ominous. Is that really the end of the line with the examiner?
It closes prosecution on the merits before the examiner, meaning they generally won't consider further substantive amendments without reopening prosecution. But it's definitely not the end for the application. You have options.
Okay. What are the main paths after getting a final rejection?
The two big ones mentioned in relation to MPP 706 and other sections are 1. File a request for continued examination, or RCE. That essentially pays a fee to reopen prosecution, so the examiner will consider further amendments or arguments. Or 2, file a notice of appeal to the PT.
So RCE keeps you with the examiner, appeal sends it upstairs to the board.
That's the gist. The appeal process, MPP 1200, involves the notice of appeal and then submitting a detailed appeal brief laying out your arguments against the examiner's rejections. The board then reviews the case based on the brief and the examiner's answer.
It seems the system, even with rejections, is built for dialogue and review. MPP 706 also mentions examiners being constructive.
Yes, that's a key theme. Examiners are encouraged, if they see allowable subject matter, even if the current claims are flawed, to sometimes suggest amendments or point out unclaimed patentable aspects disclosed in the specification. It's about facilitating prosecution when possible, not just rejecting. This constructive approach is part of ensuring fair and efficient examination.
That's good to hear. And consistency is important too, applying the same standards everywhere.
Definitely. The MPP aims for uniformity. Whether it's biotech or software or mechanical widgets, the legal standards under 101, 102, 103, 112 should be applied consistently. And don't forget interviews. MPP 700 mentions them, and they can be a really effective way to talk directly with the examiner, clear up misunderstandings, and maybe find a way around a rejection.
Makes sense. Now, beyond the normal examination process, your source material briefly mentions some other procedures related to claim validity, like protests.
Right. A protest, MPEP 1900, 37 CFR 1.291, is where a third party submits information relevant to patentability before the patent issues. An interesting procedural point from your sources: unlike many filings, these protests under 1.291 specifically cannot be filed electronically.
Okay. And reexamination.
Reexamination happens after a patent issues. It's a way to have the USPTO reconsider the patent's validity based on prior art patents or printed publications that raise a substantial new question of patentability, SNQ. Ex parte reexamination, MPP 2200, can be requested by anyone. Your sources also note inter partes reexamination, MPP 2600, but that's basically obsolete now, replaced by post-grant review procedures under the AIA.
Got it. And the last one mentioned was supplemental examination.
Supplemental examination, MPP 2800, is different again. This is requested only by the patent owner, also after the patent issues. The owner provides information could be anything, not just prior art that might raise an SNQ. The USPTO considers it. It's a way for the owner to proactively address potential validity issues they've become aware of.
So even after grant, there are ways the office can revisit claim validity.
Exactly. Shows the process doesn't necessarily end when the patent certificate is printed.
This has been incredibly helpful, really walking through MPP 706 and the whole landscape of claim rejections.
And before we wrap up, we should definitely give a shout out to Mike Shepard, the creative director behind this whole audio series.
Absolutely. And the usual but important disclaimer: this summary relied on AI tools and is for general educational purposes. It might have errors. It's not legal advice. For the definitive word, always go to the official MPEP, a qualified instructor, or a registered patent practitioner.
So recapping our journey through MPP 706 territory, we saw how examiners assess claims against the statutes, the critical split between appealable rejections and petitionable objections, the common types of rejections like 102, 103, 112, and double patenting, how you respond, and the paths forward after a final rejection like RCE or appeal.
Understanding why your claim was rejected and the specific MPT section invoked, that's really the key to figuring out your next move in prosecution. Each rejection is a hurdle, yeah, but also a chance to clarify, argue, amend, or appeal.
So here's a final thought to chew on. Given this whole complex structure, the specific rules in MPP 706 for making a rejection, the different ways to respond, the appeal options, even later challenges like reexamination, how much does the examiner's initial phrasing and framing of that very first rejection actually predetermine the entire negotiation and the ultimate scope of the patent that might issue, if any? Does that first shot almost lock in the trajectory?
A lot to think about there. Thanks for joining this deep dive. Keep exploring, keep learning.